Got mold. California has a mold problem. If your apartment or house has mold, there are strict laws about what your landlord has to do. And if they don't do it, you have rights. This is going to be very useful information, so make sure to take notes and share this with friends. If you need further assistance, we can help. You can contact us through the provided details. So first things first, spotting it early. How do you know if you have a mold problem? First, there are health risks. Maybe you're having trouble breathing, coughing, wheezing, stuff like that. Also, musty odors. That's another sign. Discoloration on walls, ceilings, windows, doors. Also, if you have hidden leaks, that could also be a sign that you have mold growing in your unit. Now, how does mold become a habitability issue? Civil Code Section 1941.1 states that it is the landlord's duty to keep the unit habitable. This means that they must make sure that all the equipment is in good working order, and it must be maintained in a manner that ensures the health and safety of the tenant. This is a basic duty of landlords. So what does that mean when it comes to mold? Well, under the Mold Statute, Health and Safety Code Section 17,920.3, also known as SB 655, mold can be considered substandard housing. So this means that if your landlord knows or should have known about the mold and failed to address it, then they've violated the statute. Next, you need to give notice. So you have to write a 3-day notice to your landlord, so they're aware of the moldy situation. Make sure to include the exact dates and times that you brought this to their attention. Keep a copy for your records and send the original via certified mail with a return receipt requested so you have proof that they got it. You want to include photos of the mold as well? If you're unable to get photos because maybe it's black mold and it's dangerous and you're afraid to be near it, then just describe it in the letter. If you need a template, we've got you covered. Then what? Well, after you deliver that notice, they then have a reasonable time to make the repairs. Now typically, this is somewhere between 7 to 14 days. But if it's an emergency like, say, black mold, then they would have to fix that right away. Next, what if your landlord doesn't respond or they ignore your notice? Well, then you have several different options. One option is that you can fix the problem yourself and deduct it from your rent. Under Civil Code Section 1942, you can make these repairs and deduct them from your rent. However, the amount of the deduction cannot exceed 1 month's rent. Another option is to withhold rent. You can withhold rent if you deliver a written notice to your landlord that you intend to withhold rent, and that you will not deliver the rent payment to the landlord, but instead you will deposit it into an escrow account. The problem with this option is that it's very risky. If you don't do it exactly right, then you could be evicted and not have the defense of needing repairs. Also, you might have a claim for unpaid rent. Another option is to go to small claims court and sue for whatever damages you've incurred. This could be past due rent, security deposits, cost of moving, etc. And throughout this process, you may want to request inspections. There are 3 types of inspections that can be helpful in a mold case. First is a code enforcement inspection. These are the city or county officials who will come out and inspect for building and housing code violations. Next is the Department of Public Health. They can do an environmental health investigation. So these are the ones that you probably want to call first, since they deal with health issues. And lastly, you may want to hire a professional to conduct a mold test. All 3 of these agencies will send someone out to do an inspection, and if they find violations, they will usually give the landlord a notice to correct the problems. In addition to all this, you need to know that under Civil Code Section 1942.5, there is anti-retaliation protections. What does that mean? Well, if you complain about mold or any other housing violation, and then your landlord raises your rent, you can sue them for the difference. So here's an example. Let's say that your rent is $2,000 per month, and you complained about mold. Similarly, if you complain about mold and then your landlord tries to evict you, then you can sue them for wrongful eviction. Now let's talk about what to do if you move out. If you decide to move out because of mold, then you may be breaking your lease. If you do this, you may be opening yourself up to liability for any unpaid rent. So you want to make sure that you review your lease carefully before taking any action. If you do decide to move out, then you want to make sure that you don't leave anything behind. Anything that you leave behind can be used as an excuse for the landlord to deny your security deposit. And speaking of security deposits, did you know that landlords are limited on how much they can charge you? Most cases, they can only charge you 1 and 2 months rent as a security deposit. This is very important because if they charge you more than that, then they're violating the law and you can sue them to get the overage portion back. Lastly, if you need help, there are several places that you can go to get free legal advice. Local legal aid organizations often have free clinics where you can go and get advice from an attorney for free. You can find legal aid by calling the CA Department of Consumer Affairs at the number provided below. You can also find a lawyer referral service through them. This will connect you with a private attorney who will be willing to take your case. This is a lot of information. Now make sure to review this information carefully. Hopefully this information is useful. If you need further assistance, we can help. You can contact us through the details provided. And also make sure to subscribe.